Um, so yeah, thank you everyone. Welcome, happy Friday. My name is Alexandra Wilson. I'm an immigration attorney. I'm one of the lawyers for family justice with the Family Justice Center in Concord here. And I did a presentation a couple of weeks ago on special immigrant juvenile status. If you didn't have a chance to catch that, that was also recorded, and the Family Justice Center has the PowerPoint, so you can request that and get some information on that great benefit for minors here in the United States. But today we're going to talk about family immigration, which is a really big category of immigration. It was a little hard for me to put this presentation together because there are so many things we could talk about. So based on what I saw as the participants involved here today, I'm not going to get too technical. I'm going to give a description of generally what the options are for folks to immigrate through a family process. And then kind of connecting it to some other issues like some domestic violence and what would happen in those situations. So I'm definitely happy to answer questions at the end or during the presentation if I don't answer all of the specific questions, and I'll try not to get too detailed and nuanced here. So just a little about myself for those of you who weren't here a couple of weeks ago. I says former lawyer for family justice. I'm still part of the program, I suppose. I just moved out of the office into my own office recently in the same building in Concord. So I'm still seeing Family Justice Center clients and involved with the Family Justice Center. But I went to law school at UC Hastings. I went to undergrad in Chicago. I'm from Ohio. I've worked at a lot of immigration nonprofits throughout law school and before. I worked for about a year at the public defender's office in this county. And yeah, added a cute picture of my dog to make everyone smile this Friday morning. That's Leo. I was sent a list of participants, so I don't think we need to go over who's participating here, but I would like to know what kind of immigration experience everyone has. If you'd like to volunteer that, if you have no idea and you're just really interested, or you or a family member has gone through an immigration process, or maybe your clients that you work with, or maybe you're an immigration attorney too. And go ahead. I don't know if I can unmute. There we go.
I have no experience.
Okay.
I'm just here to learn. Thank you.
Great. And go ahead.
Good afternoon. My name is Gladys. I do have experience with immigration matters. Actually, I've been involved in two. It's because of my husband's siblings. They've been trying to migrate over here. One of them got returned. The other one, thankfully, they made it. They're living here with us, and they're still going through the immigration process. And then I'm also filing for my husband to get his paperwork. So we're still there. We're almost there.
You're very involved then. Great.
Yes.
Hopefully I can help answer some questions for you. Okay, great. Well, I love the variety of experience here. So hopefully we can help everyone. So this is just a very broad description of the US immigration system. It's all federal law, but it's broken up into different agencies. As you can see, even within the executive branch here, we have the Department of Homeland Security, the Department of Justice, the Department of State, and HHS. All of these are going to be involved in an immigration process. Primarily today, we'll be talking about DHS, specifically USCIS and CBP, and then also the Department of State, which includes consulates and embassies outside of the United States. So those are mainly the agencies involved in a family petition. something we're not going to get talk about today is a removal. If someone's in court in removal proceedings, then that would involve the Department of Justice and EOIR, which is the Executive Office of Immigration Reform, otherwise known as the Immigration Court. And there are some family options that you can do if you're in removal proceedings, also known as deportation proceedings, but we're not going to talk about that today. So generally, when we're thinking about immigrating, the ultimate goal is a path to citizenship. So generally, there's 4 ways to get there. And of course, today we're going to be talking about the family-based immigration. Another very large category would be a refugee, asylum, and other humanitarian options like a U visa, a T visa, VAWA, and things like that. And we are going to talk a little bit about some of those today. I believe there will be another full presentation on those options later. And then there's an employment-based immigration option. Some people may have heard of like an H-1B visa, people coming here to work for like Google or something like that. And then a diversity lottery program, which we won't talk about at all today. So just a very quick background on the humanitarian options. Like I mentioned, these are the different options. We did discuss SIGIS a couple of weeks ago. So we're going to talk about some of these a little bit today in the context of a family process and how they might come into play. So there are only a few ways to becoming a US citizen. One, you were born here. Another is that you were born to US citizen parents or you were adopted by US citizen parents. And then the very last category is what we're going to be focused on today. And that's generally the largest category that, I as an immigration attorney am discussing or dealing with, is being a naturalized citizen. So that's someone who's gone through the entire immigration process, ending with, an oath for citizenship at the very end. So that being the ultimate goal. Once you're naturalized, you have a naturalization certificate, and that proves that you're a US citizen. And so just some vocabulary. So someone who is a non-immigrant is someone who comes to the United States without the intention of staying permanently. So that would be a student, a temporary worker, maybe like an agricultural worker, or someone who just comes for a brief period of time to work, let's say on airplanes or something. Tourists who come with a tourist visa, they're only intending to stay here for a short amount of time. And then anyone else who just isn't intending to remain here permanently. And then on the other hand, an immigrant is someone who is intending to remain here permanently and with the hope of naturalizing. So that could be someone who has a green card already, or someone who is an asylee, someone who was granted asylum in court here in the United States, or someone who was admitted into the United States as a refugee. And then, of course, we have undocumented immigrants, which it could be someone who entered the United States without a visa, crossing the border without any paperwork, or someone who came here with a visa, but then that visa expired and they never left. So I think this is kind of a hard concept. Like, for example, family members or friends who from Ohio will ask me, so what do you do for work? Do you just try to get people green cards? I said, well, yeah, but you can't just fill out an application and get a green card. You have to qualify for a green card first. And that's the hardest part, really. Once you already have the first part, getting the green card is the easy part. So you can't just become a citizen. The first part is to have whatever application benefits you first, and then you have a green card. And 5 years after, generally 5 years after you have a green card, you can apply for citizenship. There are exceptions to that 5-year rule. For example, asylees can apply 4 years after being granted asylum. And people who are married to US citizen spouses can apply 3 years after getting their green card. So how can you get a green card? Something we're not going to talk about a lot today would be if you had asylum, if you have a U visa, a T visa, VAWA, if you have CIVIS granted, you know, depending on the application, several, excuse me, you can be eligible to apply for a green card after a certain amount of time. Excuse me. So the family options are, you know, you can apply for a family petition, whether from within the United States or from outside of the United States. So a lot of people, I think, know this, but children who are 21 years and older can sponsor their parents. And anyone else who's 21 years and older can petition for their spouse or their siblings or their children if you're a US citizen. If you only have your green card, you can petition for your spouse and your unmarried under 21 children. That takes a little bit longer, and we'll get into that in a bit. Excuse me. Okay, excuse me. And then lastly, there's something called a fiance petition, which is maybe not something that people are very familiar with, but you can actually bring your fiance over from another country and get married here, and then the fiance would get their green card that way. And we'll discuss that a little bit today. So discussing how to do this, whether it's from within and or outside of the United States, really is a complicated discussion. It's very nuanced, but generally, somebody who can apply for their green card via a family petition and not have to leave the United States would be someone who was inspected upon arrival. So this is a weird sounding term, but really what this means is someone who is inspected was means that they entered with a visa generally. There are some exceptions and some other ways that you can be inspected. Generally what that means is that, you know, someone entered the United States through the border or at an airport, and an immigration official, namely CBP, looked at their documents, gave them a stamp, and let them come into the United States. So that could be someone who came into the United States with a tourist visa, for example. So if you have to do it from outside of the United States, that would be someone who wasn't inspected, someone who'd never entered the United States with permission or with a visa, or someone who has never been in the United States and they're currently outside of the United States. And then we could have an entire discussion on this I-601A waivers, but that involves people who are in the United States and who will eventually have to leave the United States for an interview, but will still come back into the United States with a green card. So pretty complicated, but generally that's what the options are here. And again, if you have specific questions about this, at the end, I think we can answer those, because we could have a whole discussion on just this issue. So this is one of my most asked questions. How long is it going to take? And again, it's not an easy answer. So this chart I have right here is a snippet from what's called the Visa Bulletin. That is issued by the Department of State every month, and they determine what type of categories of people from what countries can apply to come into the United States. So to be even on this list, you have to already have a petition, a family petition approved, and you're given a preference category, which we're going to talk about in a minute. And based on your preference category and what country you're from, you use this chart to determine when you can apply to come into the United States. So these are the preference categories, and I can go back to the other slide, but the first preference is going to be unmarried sons and daughters of US citizens. So again, that's of US citizens. Then the second preference category is spouses and children of LPRs, of green card holders, and then so on and so forth. You can see what the different preferences are. So I think this is our visa bulletin. I'm not sure if I can click on it. I'm going to try to take you to the active visa bulletin right now. I'm sorry. Not the most technically savvy person here. So just to show you what the visa bulletin looks like today. And so we're in February right now. The Department of State will probably be issuing a visa bulletin for March of this year. They usually do it the month before. So you can foresee what the next month will look like. But they list the preference categories here. But just to give you an example, let's say you are the spouse of a green card holder and you're from, let's say, El Salvador. So that's F2A. You just look here and that's going to be, C means current, which means you can apply right now. And we look at this chart because it says all areas except those listed. And really just depending on the different countries, some countries just have a lot more applicants than others. And for that reason, they have their own separate categories for these visa bulletins. So, you know, generally this is where you're going to come to look to see when and how long it's going to take. And I have some more examples that we can get into here. So a United States citizen petitions her brother who lives in Greece. So how long is that brother going to wait? And I can go back to the visa bulletin to give you some help. So it's a brother of a citizen from Greece. I think that's what we had. Yes. Anyone want to volunteer how long this might take?
You're only sharing your PowerPoint, so it's not sharing your full screen.
Oh, okay. Well, I'll just go back to, I'm sorry. Okay, so I'll go back here. So this, oh my God.
I'm guessing 10 years or more.
I'm sorry. Okay, back to this. So the preference category for this, he's the brother of a US citizen. So siblings of a US citizen, that's the fourth category. And assuming this is our category for this month. So F4, we're going to look in this area because Greece isn't one of the countries listed here. So this means right now that they are processing applications that were filed on March 22nd of 2007. So you use that date to calculate how long it might take. So 2022 minus 2007, what is that, about 14 years or so? So that's going to take quite a while for that Greek brother to be able to immigrate. A next example, this person has a green card and she is petitioning for a spouse who's a citizen of China. So we'll go back to this to look at the preference category. So this is going to be the second preference category because it's a spouse of a permanent resident. And then we can look at this for China, and that's F2A, China. That means it's current. So that spouse would be able to immigrate immediately. Okay. So another question, is there always a wait? And the answer is no. Immediate relatives do not have to wait. And an immediate relative is the spouse, parent, or child of a United States citizen. So sometimes someone might, let's say that that green card holder who petitioned for her spouse in China, let's say she becomes a citizen while the application is pending. That will change and expedite the process for her spouse, even though it's current right now. If in another situation, if the spouse had to wait or the family member had to wait, once the petitioner becomes a citizen, then it does expedite the process. But otherwise, anyone who's already a US citizen, it's going to be a lot faster, and there's a lot more options for the intending immigrant. For example, if someone entered the United States with a visa and then they never left, and then they married a US citizen, that person can much more easily immigrate and file for a green card than someone who is married to a green card holder. So another really important thing that we need to discuss are bars to immigrating. And there are a lot. So it's not just anyone who's married to a US citizen or anyone whose brother is a citizen or anything like that. There are a lot of roadblocks for people wanting to immigrate. So this is a big list of some of the common grounds of inadmissibility with the regulations cited there. But the first one here, present without admission or without permission, that would be someone who entered the United States without a visa. Another common one is alien smuggling. It sounds really scary, but that could be someone who, let's say a mother who entered the United States with her 2 children. She would be found inadmissible for alien smuggling because she helped other people come to the United States without permission. Similarly, maybe somebody was already here in the United States and paid for and arranged for a coyote to bring someone to the United States. That would also be considered alien smuggling. And then these 2 down here, entry after unlawful presence and EWI after unlawful presence, that would be if someone tried to enter the United States more than once, but got caught at the border and then continued to try to come into the United States or did come into the United States after being caught. And that's a really common thing that I see, especially from Central and South American clients. And really a lot of these border issues, of course, are happening on the southern border more than the Canadian border, but that's going to be, those are really common things that we see. So, and then a new rule now is a COVID vaccine. So even if you're here and you're eligible for a green card, you have to be vaccinated now. That's a new requirement and something that is coming up, and people are getting denied, whether they're at the consulate in their home country or whether they're here in the United States asking for a green card. So something very important to know, considering it takes a while to get the vaccine and you have to wait. So very important to tell your clients or friends and family members if they're going through this process. So discussing the ineligibility, the inadmissibility issues for people intending to immigrate, I thought it would be helpful to do some examples. So here we have Alice, who is a citizen of Mexico. She came into the United States without a visa when she was young. So does anyone want to answer the question of whether she's inadmissible or not? Okay, well, anyone?
I think it
Inadmissible.
might be no, because she's an immediate, she might, oh, never mind, it doesn't say that they're a citizen, but I still think it's no.
Yeah, inadmissible for presence without permission.
Yes, she is inadmissible. Unfortunately, even though she was 13, the ground of inadmissibility for having entered without permission still applies to her. And I am going to use these same examples a little bit later when we talk about waivers. So those are ways to get over the inadmissibility grounds, but for now, we'll just leave it as that she is inadmissible. Okay, now we have Brett from Peru, who came to the United States using the passport of his United States citizen twin brother. Does anyone think he is inadmissible?
Yes, because he claimed he was a citizen.
Yes, absolutely. So I'm not sure if that's here, but yes, we have false claim of US citizenship. That's a really, really tough one. It's really hard to get over that one. Don't ever want to do that. So yes, Brett is inadmissible.
So is that only when entering or while they're even here already and they mistakenly claim citizenship?
It's at any good time, or a good question. It's at any time. So sometimes people may have registered to vote. That's a huge issue because then you would be claiming to be a US citizen. If on any other tax forms or any other documents you ever claimed to be a US citizen, then it applies in those situations too. I even had a client once who was a resident. He had a green card, and for some reason when he was coming into the US, he told the officers at the border that he was a citizen. I don't know why, but unfortunately that was an issue too. So, okay, moving on, we have Corey from the Ivory Coast, and he came to the US with a B1, B2 tourist visa. And when he applied for his tourist visa application, he lied and said that he was married. Any thoughts on this?
Inadmissible because of fraud.
Yes, exactly. So we'll go back to the chart here. And yes, visa fraud. And it can be, there are a few more categories regarding fraud and misrepresentation, but yes, he is inadmissible because of the lie on his visa application. Okay, my last example here is Danielle. She tried to come into the US without a visa, but she was caught. And then she tried one more time and she was successful. And she's been here ever since 2007. She has US citizen children and she pays her taxes and she's a good citizen. Is she inadmissible?
I think so, because she came without the papers to do so.
Yeah, so this is going to be one of the more complicated entries here. So this would be IWI after IWI is entering without inspection after unlawful presence or removal, since the assumption here would be that she was apprehended by border officials and then removed, and then she re-entered. So this is a big inadmissibility ground for Danielle. So now I want to discuss some of the options for people who do have inadmissibility grounds and have issues for being able to immigrate. There are several waivers, and it really is going to depend on the way in which the person is going to apply for the green card and the relationship to the petitioner. There are also a lot of humanitarian options, so we'll get into that in a bit too. So for family immigration, these two waivers are the two big options. It's an I-601 and an I-601A hardship waiver. So the I-601A, I discussed this at the very beginning, and again, we could have a whole presentation on these types of waivers, but generally, the I-601A waiver is for anyone subject to that first ground that I mentioned, the entering the United States without permission, and it also waives someone working without permission, without a work permit. So the intending immigrant must have an approved I-130. The I-130 is the very first petition, it's a form that you file with immigration, and it's the very first thing that you do in a family case. And it really doesn't give you any immigration relief or status. All it does is allow you to then apply for a green card. And really, it just is a form and an application that shows that your relative is either a green card holder or a citizen, and that you have a relationship with that person. So for example, if we're a sibling, you would simply file both of your birth certificates to show that you have the same parents. If it were your spouse, you would file your marriage certificate, and so on. So that I-130 has to be approved first. And for this I-601A waiver, the I-130 does not have to be approved by the person you're showing a hardship to. It can be any I-130. So it could be from a sibling who filed it years and years ago, or it could be from your spouse or your parent. The important thing here is that you have to show extreme hardship to a qualifying relative. And for the I-601A waiver, a qualifying relative is only your spouse or your parent, and they have to be a green card holder or a US citizen. So this can be an issue sometimes because a lot of people might say, well, I have, US citizen children and they have disabilities. Can't I use that? Unfortunately, no. For this type of waiver, it has to be hardship to a US citizen or lawful permanent resident spouse or parent. Once the hardship waiver is approved, then the intending immigrant, the applicant, has to leave the United States for an interview in their home country, because through that interview, that is how they become inspected, which is that one requirement to becoming a green card holder. So really, I think these waivers are a little ridiculous. To be totally honest, I think it's a way for immigration to make a lot of money, because they could just have an interview here in the United States, but that's the way it is. So they have to leave the country and have an interview at a US consulate or embassy in their home country, and then or in another country, and then re-enter the United States with their green card. So this is a big area. There are a lot of people who are eligible for this type of waiver, but as you can see, it is pretty narrow. You have to only have these 2 grounds of inadmissibility here. If you tried entering more than once, you're not going to be eligible. If you have that alien smuggling or any other ground of inadmissibility, you're not going to be able to apply for this waiver. And you have to have a qualifying relative. So you have to be married to someone or have a parent who is a US citizen or a lawful permanent resident. So this process also takes a very long time. The I-601A waivers right now are taking, they're saying 36 months at this point, so a very long time. And then depending on what country you're going to, you have to wait for an appointment to open up in that country. Ciudad Juarez in Mexico, for example, it can be up to 2 years. So we're talking a very long time, but it is a successful option that a lot of people have and have done, and it is, their path to citizenship. So I think it's worth it if it's your only option, but if you have better options, easier options, then I would always recommend that. So to go back to our examples from before, Alice, I'm sorry, I don't think I discussed the I-601A waiver. That's a less complicated waiver. You still have to show hardship to a qualifying relative, but that can be filed with a green card application from within the United States, and you don't have to leave the United States. That would be for someone who was admitted. So they're not subject to this first ground of inadmissibility. So that would be someone who entered the United States with a visa, for example, and then at the green card process, they realize they're inadmissible for something else. Then they could file the I-601 waiver. So it's a lot easier because they don't have to leave the country, and it can just be filed along with the green card application, and they're able to do that at the USCIS office here in the United States. So going back to Alice, just to remind everyone, she entered the US without inspection when she was 13. And now she's married to a US citizen, and she has no other inadmissibility issues. So we determined that she is inadmissible, but does she have any options based on the waivers we just discussed? Okay, well, I'll do this one. She does have options. So she could do she's a perfect candidate for the I-601A waiver. She would just have to file that I-130 through her spouse and show that her spouse would suffer hardship if she weren't able to remain here in the United States. So Alice has some options here. Now, what about Brett? He's the one who has that false claim to US citizenship. But now he's still not married, but he does have a US citizen child. This one is a little tricky, so I'll answer this one for you. He has no qualifying relative, unfortunately. His 5-year-old cannot petition for him because he's not 21. And even if he did, his son wouldn't be a qualifying relative for either of those 2 waivers. Theoretically, because Brett entered with a passport, he could do the I-601 waiver, but that false claim to citizenship is not a ground of inadmissibility that is waivable by either of these 2 waivers. So Brett, unfortunately, has no options. His only option would be to leave the country for at least 10 years, and then he would apply for waivers from outside of the country. Okay, so Corey, hopefully someone can take a stab at this one, but Corey is the person who entered the US with a visa, but he lied on the visa, saying that he was married in Ivory Coast. So Corey was inadmissible, but now he's married to a US citizen, and he has no other inadmissibility issues. Does he have any options here?
I think no.
Okay.
Am I wrong?
I have a question. I don't know if that is the time to make it or not. Maybe like 5 years ago, I submitted an application for my mom to she can get her green card. But and we noticed that is error in her name, and we make then an appeal, and we send all the information for like if she can be able to receive a green card, but I never received nothing. So at some point I called to the immigration phone number to if they can give me some information, but they say no. So because they told me my mom needed to be present or next to me, like she give the authorization to I receive information. But after that, I never received nothing. Like how can do or what can I do to like review the case or know what is going on, if she's like able to receive one or not. Or like she now has a visa, U visa, because my son passed 4 years ago. So when my son passed, we go to request a human visa to my mom can come to my son's funeral. So she has a visa, but I don't know like what is the next step to continue like with to review the case. What can do for like know exactly what is going on.
Right. Yeah. I mean, I think offline would be a better forum for this question. It's a little detailed, but yeah, dealing with immigration and USCIS generally is a huge headache. But yeah, I think offline, if you want to send me a message, that would be better.
Okay. You need my phone number or my email, or what is the best for you?
I'll provide my contact information at the end and you can reach out.
Okay, thank you.
Let's see, Lorena, I see your hand raised. I don't know if you were trying to answer the question here.
Yes, I had a question. My mom filed documents for my cousins and my uncle in 2006. We received a letters. That's I think what they received, that they received the package. But since you can hear me?
I'm going to hold off on these questions until the end because we only have about 10 minutes left. So I want to get through the presentation, and these specific questions, like case specific questions, will be better for the end.
Okay.
So I'm just going to move on So to answer this question, Corey does have an option. He, because he came into the United States with the visa, he was inspected. So that means he can file the I-601 application with his green card application when he does that process with his wife. So that's Corey's option. Okay, last one here is Danielle. Danielle, the new facts are that she's not married. She has multiple entries without inspection and after being caught, but she has 2 US citizen children and she pays her taxes. Unfortunately, Danielle is not eligible for either of those 2 waivers because she has multiple entries. So she actually has what's called the permanent bar, which really only means 10 years. So she would have to leave the country for 10 years before being able to apply for a waiver based solely on a family option. She may have other options based on more facts in her life, but based on what we know right here, she's not eligible for anything. So this is a question I get a lot, especially through the Family Justice Center. What if my spouse petitioned for me, but since then our marriage has deteriorated or they've become abusive? So 2 of the big options here for those folks would be VAWA and I-751. So the I-751 application is for if you're married to a US citizen and you've been married for fewer than 2 years, you have to first get a 2-year green card. This was created to prevent marriage fraud a long time ago. And so now once you're married for 2 years, you have to file this I-751 application to change your green card from a conditional 2-year green card to a permanent 10-year green card. So usually you have to file this application and show that you're still married, still living together. But if at the time you need to file this application, your spouse has filed for divorce or has become abusive, you can file to remove the conditions and to become a permanent green card holder based on those facts. And it requires a lot of evidence in showing that your spouse was abusive, but it is an option. Similarly, VAWA is available for anyone who has been married to a US citizen or a lawful permanent resident. The only requirement here, in addition to showing abuse and all of that, is that the VAWA application be filed within 2 years of divorce. So these are some humanitarian options that would be discussed in a presentation later, but they are related to family petitions, so I wanted to mention those. A U visa would also be an option if, let's say, they were dating a US citizen or, they weren't actually married, then you could do a U visa as long as there was some police involvement in an issue. So here's an example. Edith came to the United States from Portugal on a fiancé visa. They got married and filed her green card application. She has her temporary green card, and now her spouse is becoming controlling and verbally abusive, and she wants to end the marriage. Does Edith have any options?
Yeah, she can file the, can she file the I-715?
Yep, she can do that. She could also do VAWA, but I would recommend the I-751 in this case because she already has her temporary green card. So that would be the quicker option for her. But yeah, she definitely has options. Okay, similarly, Frank entered the United States without permission, and then he married a US citizen spouse. But since then, his spouse has become abusive, threatens to call ICE on Frank if he reports the abuse, and he won't even file any paperwork for Frank. Does Frank have any options?
Yeah, he can, sorry, he can do the VAWA, right?
Yep.
That one would be better
Yeah.
than the I-715.
Yep.
Or he can't do the I-715, huh?
Right, because he doesn't have a petition filed already. So VAWA would be exactly for anyone who's married to a US citizen or a lawful permanent resident who doesn't already have any petitions filed.
Okay.
Okay, so that was that was it. So now I think we have, 7 minutes or so. So if anyone has questions, I think general questions would be best first, and case specific questions would probably be better by email or if we have some time at the end, but I'd be happy to answer general questions about family-based immigration at this point. Does anyone have any?
Do we wait to be called?
Can you put your contact back up? I was trying to take a picture of it and it went away.
Sorry about that.
Do we wait
There
for
is-
you to call? I can't, I mean, I'm raising my hand. We wait
Oh,
for you.
I'm sorry. Yeah. Okay, Susan, go ahead.
I just put it up. I think that the short question is to clarify to what you just said with the Edith story and the Frank story. Someone who is married, let's say more than 2 years, spouse is abusive, and what if they have they've already gotten divorced, or yeah.
That's a good question. Yeah. So if someone is married to a US citizen or a lawful permanent resident, and they already have their green card, and it's not a conditional green card, it's a permanent green card, then they can divorce their spouse. There's no negative consequences at all. At the naturalization interview, they might be asked about the status of their marriage, and they might need to show some proof that they divorced and whatever happened. Generally at that point, they're just making sure that that person didn't get married fraudulently just for an immigration benefit. But yeah.
So even if the person originally came in without permission, but then married the U.S. citizen, they can do this. Okay. I may email you with a more specific case, but yeah, that helps me.
Yeah, depending on the situation, but as long as someone has a permanent green card and it wasn't obtained fraudulently, then they don't have to remain married to an abusive spouse.
Okay.
Okay. Alaves, do you have a question?
Hi, yes. So just to clarify, the waiver of admissibility is to be able to become a legal permanent resident, because I think there's a big misunderstanding that it's a waiver so that they don't have to leave the country for the interview.
Yeah.
Right?
Well, there's 2 different types, the I-601 and then the I-601A. And just to be clear, there are a lot of other waivers. For example, with a U visa, that comes with a waiver, then you don't have to leave the country. There are waivers that you don't have to leave the country, but the I-601A, you do have to leave. There's no way around that. If you're eligible for that other waiver, the I-601, then right, you don't need to leave. So yeah, I'm not sure if there's a lot of misunderstandings out there about these types of processes, but yeah, that's just to waive any inadmissibility that's blocking you from becoming a green card holder. Okay, Hannah?
Yes, thank you. I had 2 questions. They're kind of related. Let's say that someone comes over with a coyote, and when they get here, the individuals that transported them threaten another family member that they're going to kill the person or do something or cause harm, and that they need to pay again. Is that considered like a type of human trafficking or like an act of violence? And can it be used in their defense when they are trying to petition?
So I think in the more like humanitarian presentation, they'll go into this in more detail, but depending on the situation, it could be trafficking if the coyote was forcing them to work or forcing them to do something without payment in order to pay off the debt that they say they owe. But so depending on the situation.
Okay, and then what about, I know we mentioned like domestic violence between intimate partners, but what about violence like in general, like being a victim?
Yeah. So again, this would be something that's going to be discussed in the humanitarian presentation, but that could be a U visa, and also VAWA. You can apply for VAWA if you've been abused by your children, also, so, or your parents. So there are definitely other options there, but the humanitarian presentation was, it's very detailed, so they'll definitely go into that.
Okay, thank you.
We do have just some additional minutes, so I did want to bring that up. I, don't want the meeting to just, completely end like that. And just wanted to say thank you so much, Alex, for your time, for enlightening us with all of this information. I know it's, like never ending, right? There's always so much to learn, but definitely everyone will receive these slides emailed. You can request the recording as well. And like Alex mentioned, her contact information is provided here as well. And thank you for everyone for your time and your support.
Sure. I have a couple minutes. Should I answer some more? Okay, I think Dahlia?
Yes, could you speak on the public charge related to inadmissibility?
Yeah, that's a good question. Very complicated response. There's been so much litigation on it. It's been an issue. It hasn't been an issue. A really general answer right now is that it is not an inadmissibility issue at this point, not like it was under the previous administration. So generally applying for like Medi-Cal isn't going to be a big issue. What's more important is showing that your sponsor can financially support you when you're here. But it's a complicated issue, but it's not as big of a problem as it used to be. And then Gladys, I've seen your hand up for a while. I'm sorry, go ahead.
I have two quick questions. The first question is it possible to get the visa approved before going to the interview?
No, no.
Okay.
I mean, yes and no. Sometimes they will approve a visa without an interview, and I've actually seen it happening more recently, I think because of COVID and all the backlogs, but generally no. Yes and no. Hard.
And then also the other question is, what would happen if like people get married together and then they file the paperwork, but then they're like, oh, I'm gonna divorce that person because once I get the paper. What would happen in that case?
It depends on the situation, but maybe the I-751 or VAWA could be an option for the petitioner.
Okay, thank you.
And then Swastika, did you have a question?
Thank you so much for your presentation. It was much needed. I have a client who lied during a visa interview saying that he doesn't have siblings, but he has siblings. Does it affect his immigration status here? He's legal resident, right? And can his siblings apply to US visa?
He has, I'm sorry, the question, he has siblings, but what was the situation?
He lied during the visa interview that he hadn't, he's only the child of the parents.
I see. No, it shouldn't affect his siblings necessarily. They didn't lie, so.
And sorry, does his immigration status get affected if their siblings, if his siblings is to apply for US visa?
It could definitely. If he has a green card now, that is something that could come up at the citizenship stage. They could see that his siblings applied and listed him as a sibling. So, yeah, that's certainly something that could come up at the naturalization stage.
Thank you.
You're welcome. All right, I think we're over time now. So like was already discussed, this is going to be shared with everyone. So if you didn't get a chance to write my information down, it'll be sent out. And thanks everyone. Hope it was helpful, and feel free to reach out if you have questions.
Can someone just tell when is the humanitarian presentation? I'm sorry, I missed that.
I'm not sure. Go ahead.
You will also receive emails with those reminders to register for them, and definitely look forward in your email with them.
Okay, sorry to interrupt. Thank you so much for your time, everybody.
Sure. Have a nice weekend, y'all.
Thank you, everyone. Thank you for your time. guys
Thank
have
you.
a good-
Bye-bye.
Bye.